All of the rules that apply to the prosecution to disclose all of their evidence and strong points of the case does not apply to the defense, and defense has really limited need to disclose their evidence and statements. It is important to understand that criminal trials, the defense have very limited duty of disclosure. A suspect who has been arrested has no obligation to answer to any of the police questions. So the first thing what happens when a police arrests a person, he is given the right to stay silent, because anything he may say shall be used against him in the court of law. Once the case comes to the trial, he is not obliged to give evidence himself or to call any witness. So once he has been produced into the court, then it is the duty of the prosecution to prove the case against him, and he can simply say that you prove the case against me. So it is the duty of the prosecution to prove the facts through evidence against the defense. But the exception to it is that the jury may make adverse inferences against the defendant in the case of his silence. So in addition, the government has provided that if the case goes to the Crown Court, the defendant is obliged to serve the defense statement and a notification of defense witnesses. The defense statement is a document which is simply says that the defense is the defendant was acting in self-defense if he was about to take that plea, and in what respect the defendant disagrees to the prosecution case. The notification of defense statement is a notification to prosecution of the names and addresses of the witnesses and the defendant proposes to call at trial. This requirement only applies to the Crown Court, and there is no requirement of even these limited measures of disclosure before the trial in the magistrate court. It is important to note the following: if the defendant fails to serve either of the documents set above, while the jury may be allowed to draw inferences against him from that failure, it is still the prosecution case to prove by calling its evidence. The defendant does not automatically lose. So even if the defendant does not provide the defense statement, he does not become the convicted at once, but the prosecution still have to prove the case against him. Secondly, the defendant is under no obligation to serve on prosecution the witness statements of any witness he proposes to call in his defense. So prosecution has to tell the court which kind of witness statements of any witness they are about to provide, but this condition does not apply to defense. They just have to give the name and addresses of the witnesses they want to provide. Thirdly, if the defense having in their possession evidence that is highly prejudicial to the defense, for example, they have interviewed witnesses who said he definitely did it, there is no obligation to notify the prosecution of the existence of that kind of evidence of those witnesses. But if prosecution has that kind of evidence against the defense, then the prosecution does have the obligation to provide the court and the defense about that kind of witness statements that are going against the defendant's case. So the defense disclosure is quite limited in comparison with the prosecution disclosure.